How much of your estate would be lost to probate fees? Now, I know this is a pretty, it's not something everybody wants to talk about, right? It's what happens when we pass, or what happens if we get incapacitated. But I'm just going to focus like a laser beam on that first question. What happens if we pass away? Because there's really only three ways things are handled. Number one, I didn't do anything, and I end up going through the process dictated by the state that's called dying intestate. And folks that have no will or no living trust go through that process, and you fall under state law. A famous example is Prince, the artist who passed away with no estate plan, and everybody and their mother was coming out of the woodwork saying that they were an heir to his estate, and it took years and got depleted significantly because he had no documentation. The second way is to do a will. And a will is a grease slide right into probate. Again, it's a legal process set up that you're going through the court to determine who gets parts of your estate. And a will is a guarantee to go through the probate process. And the problem with probate is it's expensive and time consuming. But lawyers will tell you it's not that bad in my state. And I always say, not that bad for who? Because a 6-month delay to somebody who's grieving, who has to worry about an estate, can be significant. A 6-month delay, as in what's happened multiple times in our economy when real estate's taken a tank, can cost you millions of dollars in an estate. And of course, it's not that big of a deal. No, that's just not what we're going to do. Number three, that is using a living trust. And that avoids probate so long as the living trust is properly executed and funded. And what that does is it takes the items from being yours to the estate. Now, why would I do this? Number one and number two are prohibitively expensive. In fact, AARP did a study, and then it got smushed down when it got released because the attorneys didn't like it. And what it showed is that the estate planning world and the probate world, they were making billions of dollars a year probating estates. In fact, it's a huge money generator for the legal profession. I'm a part of it. I remember going through wills and trusts and everybody saying, you should do a will, get them a will, because that way you can shepherd their estate when they pass. And I remember going through a few of those probates. It's a long process. On average, you're looking at about 18 months. It depends on your state, but it can be a very long process depending on the complexity of your affairs. But generally, around 18 months. Now, that's not just me. AARP said the same thing. It was about 18 to 24 months, and it ate up, get this, approximately 20% of most mid to low size estates. So I'm talking about $1 million or below. It's eating up an enormous portion of it. But let's just talk about average Americans. Maybe you have a median household and it goes through probate. I will show you right now I'll show you a fee schedule that was just sent to me about 2 months ago. This is in Pennsylvania, and this was a single property encumbered going through probate. And what you could see there quite clearly is that for that estate, we were looking at about $13,500 to probate the house. Not to mention, they were going to sell the property and it was going to eat up more of the estate. Now, here's the interesting part. When you go through this process, because there was a will and they were just transferring it to their daughter, dad passed away, $13,500 is the attorney's fees. Thank God the daughter was able to act as the personal representative. Otherwise, you would have been paying somebody else as well, as is our example number 2. When we go to California, it is literally a percentage of the gross estate that is charged. So in this particular case, it's 4% of the first $100,000 for the attorney and 4% for the personal representative. So it's 8% total of that first 100. So 8,000, keep that in mind. It's another 3% on the next 100,000, 3% for the personal rep and the lawyer, so another $6,000. So 8 plus 6 is 14,000. And then on the next 100,000, it would have been 2%, for the attorney, 2% for the personal representative, or $18,000. So on a $300,000 property, you would have been looking at $18,000 of just the legal cost of going through probate, not to mention the court costs, the experts, the appraisals, and everything else. Now you understand why it gets to be so expensive so quickly. And since you're going through a legal process, it can be very expensive and very time consuming. And so we want to avoid that. And that's why we use living trust. Sometimes I deal with some of my brethren in the profession and they're like, not a big deal, small estate. I can almost understand it. But my clientele is almost all real estate investors. It's people with businesses, and it's people who want to create legacies. You cannot do that intestate. You cannot do that with a will. You have to be very deliberate, and you want to control where that estate goes. You need to have a trust in place, period. There isn't an alternative. Some people will say, well, do some joint ownership. Put your kids on the property. That is wrought with all sorts of problems, not just from a tax standpoint, from a risk standpoint, and a control standpoint. Medicare, all sorts of things come in and get triggered as a result of doing some of this nonsense. And you have gifting issues. Don't fall for the lame, simple, here's all you have to do excuse. A thoughtful estate plan covers multiple facets of your world, including your health, making sure that you have advocates who can get access to your medical information and advocate for you if you're not able to advocate for yourself, covering your financial, making sure that if you're incapacitated, you have somebody there who can still act and advocate for you with third parties, whether it be for paying for things or handling your affairs. You want to have something put in writing for end-of-life decisions. Do I want extraordinary measures taken? Or do I want to have extraordinary measures taken? Or do I want to be allowed to go under my terms and have somebody advocating for me and communicating with my doctor who says, no, I don't want my, whoever it is, if they're representing you, maybe it's your parent, maybe it's a child, I don't want them to continue to suffer. I want that to be minimized, and I don't want them to be kept in this state, right? In going through what they're going through. That is called a living will at that point. And then you have, how do I want my estate to be handled? And if you want to create generational wealth, you really do need to have that living trust, because that way you can put in protections so that if you have a child who has alcohol problems, drug problems, they're just not old enough, you can put in restrictions, or you could put in, hey, I don't want you taking the principal away. I'm fine with you using it for health, education, maintenance, and support, things like that, but I don't want you going out and buying a brand new Lamborghini with all the work that I put in. I want that to be there for additional generations, for my grandkids, for my great-grandkids, or for the organizations I care about. I need to have that living trust in place in order to do that. I cannot do that through a simple will or through doing nothing, where I just let the state decide. It requires some thought and a little bit of effort, but at the end of the day, it's considerably less expensive. And this is my experience and the experience of many others in my profession. It is significantly less expensive than going through a drawn-out court process and dealing with all those attorney's fees and personal representative fees that get charged on top of it, depleting the estate when you could have quickly and easily resolved the estate by putting it in writing and putting it into trust. So if you would like to learn whether a trust is right for you, click the strategy session, and it's a no cost, no obligation consult. Somebody will go over the basics with you and what it would look like for you and what the cost would be, so that you could avoid the probate process and make sure that you're passing on your estate in a loving and caring way, as opposed to requiring that your heirs go through a court process during a time when they're probably not so much in the mood to be going to a court process, right? They're grieving. And if you want to put something into writing and make sure that your estate is honored and that your values can be passed on to future generations. And I don't say that lightly. You can put a lot of thought into your estate where it might be, hey, I think that travel is really important. I want you to get outside the United States. I want you to visit other countries. You can literally write that into your document that that's what you want a portion of the money's used for beneficiaries to travel, to do mission work, to do whatever you believe is important that they do. I want you to graduate from college. I want you to get an advanced degree. You can put incentives. You can put requirements in so that you can actually have control of your estate even though you're no longer here. You can do that with a living trust. And so if you're interested in learning more, by all means, click on that link to request a strategy session and create a plan that benefits you and does not allow your estate to get eaten up with prohibitive costs of attorney's fees, personal representative fees, or court costs.